Hi, thank you for joining us, and welcome to this installment of David W. Klasing's Clarifying Tax Situations.
What do you need to know as a taxpayer where you've got tax litigation against the IRS? First of all, when might you need to litigate? Well, litigation becomes necessary when you go through an audit and the IRS either relies on the wrong facts or the wrong law and reaches a wrong legal conclusion, and as usual, that legal conclusion leads to additional tax liability. You may need to litigate that issue to get it to go away. How does the litigation process begin? Well, first of all, if you have an audit and you're sitting there looking at the auditor's report and they're asking you for $300,000 of additional tax, and they're either assuming facts that you know aren't true, or they're stating the law that your tax advisor is telling you is the incorrect law and they're reaching a wrong conclusion, you really only have two choices. You can either allow them to assess the tax and pay it, or fight it. If you choose to fight it, what you're going to need to do is file a tax court petition. If you file a tax court petition, what's going to happen is that's going to get you into the IRS appeals process. The IRS appeals officers are taught to weigh the hazards of litigation. For example, if the appeals officer thinks they have a 50% chance of winning the issue in litigation, they might be willing to compromise the amount you owe. Let's say it's a $100,000 proposed assessment down to $50,000. In other words, 50% chance of winning, they'll only hit you for 50% of the assessment. This can be achieved without litigation in the appeals process, but you need to file a tax court petition to get that opportunity. You also need to have someone who's very adept at making it clear to them that they do have hazards of litigation and that you're going to win, they're going to lose. They should settle the issue with you right then and there. Tax attorneys have an advantage in the appeals process in that while it's true that EAs, CTEC certified preparers, and CPAs can appear for you in the appeals process, attorneys are much more adept at getting the appeals officer to realize that they have hazards if they litigate the issue. And who's going to be more convincing that you intend to litigate than a tax attorney who's ready to take it there? Matter of fact, if you can't get the result you're looking for in appeals, only an attorney can take it to the next step. There's one more opportunity to settle the case without litigation, and that's once the appeals officer washes their hands of the issue and passes it on to Chief Counsel's office. Only an attorney can show up and interact with the Office of Chief Counsel. Why specifically you would want to use me in litigation is approximately 1% of attorneys are also CPAs. I'm in that 1%. I understand it from the accounting to the tax preparation to the interaction with the IRS and the audit, to the appeals process, to trying to reach a settlement with Chief Counsel's office, and ultimately, if you have to go to tax court litigation, I used to be the chair of the California State Bar Tax Procedure and Litigation Committee. I'd love to take you there. If you actually get to tax court, there's only two ways somebody is authorized to represent you in tax court. Either they're an attorney that's admitted to practice in tax court, or they're somebody that have passed the tax court examination, which is rumored to have a 2% pass rate. There are a few CPAs that are sophisticated enough to pass the tax court examination, but ordinarily they've been to law school, they failed the bar, but they managed to pass that exam.